Good afternoon. Your attention, please. No, sir. Good afternoon. We begin the third session today. I'll be very, very brief. I only have one question, probably for the Italian or European contingency, and that is that migration has taken place since ancient times, prehistory times. But what bothers us today is not necessarily the migration that migrate for economic reasons, but rather for the wars that we are created. And I was thinking that perhaps someone today or tomorrow could talk about the link between war and the migratory problems that are being created, which are really very, very, yeah. War.
Migration has created war.
No, not to end war. Migration link. You link together the two because war has very much to do, or immigration has to do very much with war. So I was hoping that the European side would talk about this subject because I think it's the most dramatic and tragic event that we are living today, and not necessarily because of economic reasons. Migration, as Professor Mignoni said, it's forced migration. They are running away from something, and I think we should talk about it. We have three speakers today. The first speaker will be Tiffany Joseph, who is an assistant professor of sociology and an affiliate faculty Latin American Caribbean Studies at Stony Brook University. She recently explores comparative frameworks of race migration in the Americas and micro-level impact on macro-level public policies. Her current project examines the immigrants' health care access under the Affordable Care Act. The second speaker is Claudio Rossi, a sociologist, has been working since 1992 on policies for the integration of immigrant communities. He's a co-founder of a special immigration office in the municipality of Rome, Italy, where he has been involved in designing and programming of integrated services for immigration population, and he has done that for many years. He specializes in matters relating to the representation of foreign citizenship, and as a member of the Co-RIS Immigration Observatory at La Sapienza University in Rome, he has several master's degrees. And the last speaker is Sonia Diaz Inoa, Esquire. She's a PhD in democratic society, specifically for the state and the law, from the University of del País Vasco. And she holds a master's degree in human rights protection from the University, La Universidad de Alcalá de Henares, both from Spain. She also holds a master's degree in public administration and a law degree, both received from the Pontificia Universidad Católica de Madre y Maestra of Santo Domingo. She's a research professor at Universidad Autonoma de Santo Domingo in the subject of administration law and penitentiary law, and has a working experience in the state's area or the government's area. At the theoretical level, she works in the matter of migration, human rights, and gender. She is a practicing lawyer and a volunteer in the civic movement named Participación Ciudadana. Sonia Diaz Inoa an Esquire and a PhD holder, and she's from the Pontificia Universidad Católica Madre y Maestra of Santo Domingo. Abra. Yeah.
Thank you. Good afternoon. Thank you for inviting those Universidad Autónoma de Santo Domingo at this event. Thank you, Don Mario. This is legal status of person born in the Dominican Republic of undocumented aliens as the entry into force of the law 169/14, which establishes a special regime for persons born in the national territory registered irregularly in the Dominican Civil Register and naturalization. Excuse me.
Next page. Maybe next time.
¿Dónde le voy a dar?
Next page.
And also, you can also
No.
use this. Is this what you need?
I need the whole,
Yeah, it shows up
okay.
So-
Where do I take the
right here.
Okay,
Or here.
thank you, here,
Yeah.
okay. Sentence 168/13. The culmination of the latent problem in the Dominican society is materialized in the sentence 168 issued by the Constitutional Court on September 23, 2013. Briefly, assimilation of the foreign in transit concept to that undocumented immigrant. This sentence assimilates the concept of foreigners in transit and undocumented aliens without taking into account the time they had living in the country, as in the case of the appellant of the ground of unconstitutionality before the court, whose family has several decades residing in the Dominican Republic, and she and her children were born in the country. Inventory ordered to the Central Electoral Board with retroactive character. In sentence 168, the Constitutional Court ordered the Central Electoral Board to make an inventory of persons registered irregularly in the civil register from 1929 to 2007. This decision violates the principle of non-retroactivity of the law enshrined in both in the Dominican Constitution and Civil Code, as the tribunal retroactively applied the current Constitution of 2010. Irregularly referred to documents that the parents present in the Dominican Civil Register when they went to register or declare their children as Dominican citizens. This Magna Carta, in its Article 18, consacred the principle of jus sanguinis as a requirement to acquire Dominican nationality, unlike those that precede it contemplating the principle of jus sanguinis and jus soli combined to acquire such nationality. the debate caused by sentence 16A. This judgment affected a considerable number of people. The situation provoked a great national and international debate, attracting the participation of organizations such as United Nations, whose Secretary General visited the Dominican Republic, and regional organizations as the Inter-American Commission on Human Rights, which made an on-site observation visit to the country. Likewise, personality, intellectuals, and academics came forward stating a judgment 16A violate human rights. In the face of this pronouncement, the national and international pressure, the Dominican government tried to find a solution to the serious problem created by the Constitution Court with its ruling. To remedy the situation, Law 169/14 was enacted and established a special regime for people born in the national territory, registered irregularly in the Dominican Civil Register, and naturalization. Law 169 divides the population group affected by sentence 168 into two categories. Group A, consisting of children of undocumented aliens who were registered in the Dominican Civil Register, and Group B, composed of those who were not. This law only partially solves the problem, since although a considerable number of people have benefited from it, a significant part of the affected population has not been able to comply with requirements established by the Central Electoral Board. Immigrant and descendants of immigrants born in the Dominican Republic. Total population of DR, 9.7 million of people, 100%. Born abroad, 524,000, it's 5.4% of the population. Born in DR of immigrant parents, 244,000, it's 2.5% of the population. Total immigrants and descendants, 768,000. It's 8% of the population. Born in Dominican Republic of Asian origin, 209,000. It's 100% born in Dominican Republic from Asian origin. It have their birth certificate 115,000. Measures taken to remedy the consequence of sentence TC 168. As not above, the Dominican government sought to remedy the situation with Law 169. As already stated, the effectiveness of this instrument has been limited. An important part of the interviews estimated in 5,000 people, the members of the Group A, which is the number published by Central Electoral Board according to the inventory they made, who were registered in the civil register. Nevertheless, the interviewer pointed out that that group, only 13,000 people, had been able to full comply with the process and retrieve their documents. On the other hand, of those in Group B, that is supposed to be the most numerous, there are a large number of people in the Dominican Republic who do not have birth certificate, both Dominican and children of undocumented aliens. Only 6,700 could be registered in the National Plan for Regularization of Immigrants, registration that supposedly will allow them to later access nationalization as Dominicans. It should be understood that many people have yet to regularize their situation, both in Group A and Group B. The exact number of these people has not yet been determined, all of which are stateless, having no citizenship of any country. Theoretical and ideological base for sentence 168. The ideological foundation that support 168 had been constituted since the 19th century and have materialized in the second decade of the 21st century. Its starting point is the Hispanidad and the negation of the African origins of Dominican society. Throughout our history, this racist view has predominated in national elite and has been disguised as nationalist. This ideological perspective is reflected in various facets of national life, in schools, in literature, in history, and across social strata. When asked interview, do you think the sentence 168/13 reflects an ideology? 50 of the interviewers considered that the sentence 168 does contain some ideology. The majority expressed that the sentence emanated from the racist and xenophobic ideological substratum, a characteristic of the Dominican conservatives as they assumed by members of the Constitutional Court. For this ideological vision, nationality is not defined by legal and political ties, but by ethnicity and culture. Instead, an exclusive nationalism deriving from the particular history shared by the Dominican Republic and Haiti. This nationalism insists on the preservation of territory, language, race, culture, in short, identity, which would be threatened by Haiti. How do the key actors in process perceive the question of the legal status of children born in Dominican Republic of undocumented immigrants residing in the country? An important part of the key actor in the process that were interviewed considered that Law 169, while benefiting a considerable number of people who have regained the Dominican nationality from which they had been deprived before 168 by administrative decision of the Central Electoral Board, have continued to suffer many abuse and limitations, as they were prevented from accessing records of the civil status and all kinds of identity documents. In fact, their hours in life were suspended, since from that moment on they could no longer find work, study, marry, or declare their children, or appeal to the justice system. Conclusion. Sentence TC 168/13, denationalize an indeterminate number of people who had documents accrediting them as Dominicans, and others that, although having no documents, feel they are Dominican nationals because they were born, grow, reproduce in the Dominican Republic. This is their country and they don't know another. They coexist with and have a culture of the Dominican people. B. Sentence 168 is a result of an ideological vision, real historical, based on racism and hence contempt for the black and African group of the Dominican society. C. Law 169 solve the problem of the legal status of a small number of people for whom reliable statistics are not available. However, when comparing the official figure with the statistics resulting for the first national immigrant survey, the number of the beneficiaries appear to be very small. As some interviewers think, the idea would have been to establish a law of legislative validation, recognizing the nationality of the sons and daughters of immigrants as an irregular migratory situation born before entering force of 2010 Constitution, which established the principle of jus sanguinis as a requirement to acquire Dominican nationality. An important number of the members of the Group A is in what's some have called a legal limbo, because although they are declared as Dominicans, they don't know what step to take to be endowed with identity documents. The vast majority of members of Group B were not even registered in the book of foreigners because they could not fulfill all the established requirements or for indeterminate reason. That's why today they can only be considered stateless. They do not possess nationality of any country. G. The only beneficial decision contained in the TC 168/13 is that it forced the Dominican government to implement the National Plan of Regularization of Foreigners, which, although it was already a mandate of the General Migration Law of 2004, it had not been implemented. The Dominican state has to take measures to enable those affected by Sentence 168 to recover or obtain Dominican nationality, since Law 169/14 failed to solve the problem. Thank you.
Any question? Yeah.
I have a question.
For whom?
I have a question for Tiffany. So I for your first, so in terms of your first question about the comparative aspects of the study, differences between when I conducted the research in 2012 to 2013 and then 2015 to 2016, basically what Massachusetts did was it essentially rewrote its health policy so that anyone who was living in the state of Massachusetts would not lose any coverage that they had access to once Obamacare was implemented. So that required the state really doing some finessing, particularly for immigrants who had green cards who were here for less than 5 years. So they really had to tweak one of their original Massachusetts coverage programs so that that population would not lose coverage under the ACA because that group is pretty much excluded. But they had to use state-level funding to do that. The other thing, aside from the policy, is that when I was conducting this research, it was sort of at the height of this most recent election cycle, and it came up in some of my interviews from immigrants, from some of the healthcare providers, and also some of the immigrant and health advocacy organization employees, that they were already starting to see the impact of the rhetoric shaping or affecting immigrants' willingness to come in for health services and to even apply for coverage that they were eligible for out of issues of concerns about fear and what that might lead to in terms of deportation. So the rhetoric at the national level in the campaign was already having an impact at the local level in Boston. And there was much more anti-immigrant sentiment reported in the 2015 to 2016 data compared to the 2012 to 2013 data. Your other question in terms of the notion of sanctuary hospitals, that's a term that the immigrant populations were not very aware of in terms of that technical term, but people felt that the healthcare facilities that they went to were very safe spaces for them, particularly within the Boston Health Coalition, which is the multi-hospital and healthcare facility system